Okay. Well, we're on at the moment a little over 150, so I'm going to make a start because we're at 11:03 at the moment. Can I first of all start off by welcoming you? I hope, and somebody's told me they can see the screen. Doesn't matter so much whether you can see me as long as you can hear me. This is a seminar on Airbnb type bookings and its impact upon social housing, and in particular landlords' possible actions if their tenants are carrying out such activity, should they wish to take such action. I'm Andy Lane. I'm a barrister at Cornerstone Barristers. I'm a member of the Housing and Public Law teams. I have a particular interest because I wrote Cornerstone on social housing fraud, which included obviously elements of Airbnb fraud. And I also run the Cornerstone on social housing fraud blog, which has updated that in the sense of more recent activity, some of which we will come across as we go through this session. I should say this is my first solo effort, so apologies if there's any problems. That's undoubtedly my fault. But let's make a start. And I should just say that all this is saying is that it's recorded. It will be available both on the Chamber's website and on YouTube. I understand they have to do some doctoring, probably quite a lot in my case, before it goes on YouTube, but it will be on the Chamber's website. In terms of what we're going to be dealing with, I'm going to focus in particular on areas 3 and 4. In other words, is the carrying out of Airbnb type activity, breach of tenancy, and is it a sublet or parting with possession? And of course, that question is particularly relevant where we come to periodic or fixed term stroke flexible tenancies, more than long leases and shared ownership leases. But I am going to very briefly explain Airbnb type accommodation. I'm going to look at the fairly clear and understandable long lease tenancy distinction, and that's particularly with a view to shared ownership. I'm going to look at subletting, and I'm going to look at breaches of tenancy, as I say. And at the end, not to any great extent, but I'm going to point out some of the issues on possession action and money claims, not least because of coronavirus restrictions and so on. And hopefully there will be time for a Q&A. One never knows, and barristers' time estimates are never to be believed, but hopefully there'll be time. Can I say, to start off with, I have tried to incorporate some of the questions that came through on the booking forms within my presentation. One of those that I hadn't anticipated dealing with, a number of people asked questions about the impact on Airbnb type activity on Housing Act licensing, whether that's HMO mandatory licensing, additional licensing, or selective licensing. And in broad terms, as I haven't covered it in the slides, but in broad terms, what I would say is it's unlikely to involve additional or mandatory HMO licensing, because this type of activity doesn't create only or main residences. In other words, people going into occupation, they have somewhere else to live. They're staying there for a few weeks, not always, but generally speaking, a few days to a few weeks. So it's not their only or main residence, and therefore they wouldn't come within the HMO definition you see at section 254 of the Housing Act of 2004. Selective licensing is perhaps more interesting, although I think probably not in most instances, not least because holiday lets are excluded. So I wouldn't close the door entirely on selective licensing, but in general terms, for most of this type of activity, I would say it's not especially a relevant issue. What I should also say very briefly is that the expert on this is my roommate, Dean Underwood, and I had a long chat with him yesterday to make sure I wasn't going completely off track, and he confirmed that in broad terms that's right. So it's a very good question, but in general terms, that's not the issue here. In terms of the different scenarios, when we talk about short-term lets, whether it's booking.com or Airbnb or whoever, it's obviously not just one type of thing. So for example, some tenants let out rooms and remain at the property. I mean, a friend of mine does that with her long lease. She still lives at the property, but she lets out the second room on short-term lets. Sometimes, and this I suspect is where most people's concern is, the tenant lives elsewhere. And clearly that's not a proper use of social housing, although it's a bit more nuanced with shared ownership, and certainly more nuanced with long leases. But that's normally the concern that most landlords would have. Sometimes the tenant is temporarily absent and using the property during their absence for short-term lets. Maybe they're working abroad for a while, maybe they're staying elsewhere for holiday purposes and using the property in the meantime. And that comes into the occasional use for short-term lets. In other words, it's not what they're using the property for 365 days a year, but it is something that occasionally they would do. Tenants under shared ownership agreements are a particular issue, not least because of means of enforcement. And we'll see as we go along, a lot of the remedies there are relating to injunctions. And similarly with the tenants under a long lease, which I appreciate are not really the main concern of social housing providers. And of course, there is sometimes an allegation that it's a third party that's arranged a short-term let. It's one of the allegations that comes up in one of the cases I'll be looking at later. It doesn't necessarily therefore need to be a bad thing. I mean, to some extent, if somebody wants to use their room, for a little bit of extra cash, it may not be the worst thing in the world, as long as they stay living there, as long as they declare that income for tax purposes, as long as they declare that income for benefit purposes. But it may be a problem, and therefore it's increasing use of these type of websites, and therefore it's something that we need to look at as to whether it in fact creates a problem which a landlord can deal with. Somebody in the booking quite rightly identified my motivation for this webinar was a recent Upper Tribunal Lands Chamber case of Triplerose and Beattie. And the reason why that was the case is that this was a decision of the 4th of June 2020 by the Deputy Chamber President, Martin Roger QC, having had the remote hearing a few days previously. And the question that was before the Deputy President was, did a short-term let breach the term not to use the flat for any purpose other than as a private dwelling house for occupation by one family at any one time? And of course, one might take the view, well, if the tenant's not there, but there is somebody else there, they are using it for occupation by family at any one time. And in this case, the first tier tribunal, Property Chamber, refused to make the required declaration of breach, which you need if you're going to go on for forfeiture proceedings in long lease and other cases. They refused to make that declaration. They distinguished a case we'll come on to look at, Nemkova, and said it was not in breach of the clause and not in breach of the business user clause either. In other words, it was ancillary to the Beattie's own use of the property. What they really looked at in this case was, well, is that really sustainable? And the problem that the Deputy President identified was that it's fair enough to say the business use clause wasn't breached because you had to look at the particular clause. And here the covenant was against carrying on a business and it was actually being carried on elsewhere. And therefore, because of the clause's wording, that was fair enough. That wasn't a breach. But was a breach of the use as a residence for one family, etc., that I identified. And the reason for that is that there needs to be a degree of permanence. In other words, if one's having short-term lets, whether they're for matters of days or weeks, that doesn't create the short-term, that doesn't create the permanence required for use of the property as a dwelling house. And therefore, in those cases, there had been a breach. And I should just say, this is the kind of development and confirmation, perhaps, of previous cases that will be dealt with in the Cornerstone on Social Housing Fraud second edition, which hopefully will be out next year. So what is Airbnb? And this is, I'm going to rush through these because you will probably know better than I've ever used it once in LA, but on a holiday, but it's basically a contact base between people who have rooms let and people who wish to rent them. Commission is received from both the hosts and the guests. It's clearly short-term lets. Within London, Airbnb, for example, impose a 90-day limit unless there's planning permission for more. The Mayor of London wants to have a registration scheme to make sure it's properly regulated. And the last warning is that, of course, there is no breakfast in most cases. There may be food provided, but it's not really a bed and breakfast. It's really a short-term let, as is better described. Just to make the point in terms of London and the 90-day issue, it hasn't just come out of nowhere. The Deregulation Act amended the 73 Act you see there to say that there's no planning breach as long as you didn't let out your property on a short-term rental for more than 90 nights. If you came within that, there was no change of use and therefore no requirement for planning permission. Because before that, there was an issue with planning as well as other issues such as breach of lease and such like. Now, the judgment of Paris, it's not the Trojan War matter and it's not the founding of Rome matter. It's a matter that some of you will have seen on the Twitter account for Cornerstone on social housing fraud. I may have read independently of that anyway. Because this was a case in Paris where Airbnb were found to be in breach of their obligations and required to pay compensation, as you'll see from the penultimate bullet point, because they hadn't properly inspected the advertisements for a flat which was being let through Airbnb, and therefore they were liable for it. I've only raised it at this point to make the point that normally we're talking about the tenant's liability, and whether that's in damages, whether that's in injunction, whether that's in respect of possession proceedings, we're talking about the tenant's liability. There is a possibility, perhaps, that there is a further liability for Airbnb, although I should just stress, as you can see from that slide, that is a matter of appeal. So before we get on to the subletting, let's just quickly remind ourselves what the distinction is between long lease and tenancy. It's important for remedy purposes. In other words, a breach of a lease is going to be different than the breach of a periodic tenancy, for example. It's going to be different from the type of tenancy terms you might expect to see. They're going to be different. And for example, in long leases, there may be, and normally isn't any requirement you live there personally as you own your principal home. Where of course, in a periodic lease or in a flexible tenancy or in a fixed term tenancy for a social landlord, there is that requirement. And it will obviously therefore, because of those reasons, impact upon the forms of action a landlord may wish or be able to take. So what is a long lease? Well, effectively it's a lease for more than 21 years. And so that's the fairly straightforward point. So when we're dealing with things like fixed term tenancies, when we're dealing with flexible tenancies, of course, they're nowhere near that length, and therefore they're not long leases. And therefore they don't have the requirements, for example, to have a declaration of breach before there is any requirement to go through forfeiture. So it's going to be a 21-year plus lease. And you'll see I've made at the second and third bullet points reference to the fact that they can't be secure tenancies. You can see that from the 85 Act reference, and you can see from the 88 Act reference. The important difference in approach is because, of course, you do have shared ownership. And for those of you who don't know, although I'm sure most of you do, shared ownership is an assured tenancy. It's effectively normally an assured short-hold tenancy, albeit it's for a 99-year, with the idea that the tenant can staircase their interest in the property up 100%. When they get to 100%, of course, they've got a long lease. Up to that point, they are an assured tenancy. And so long as they live at the property, they are subject, certain exceptions, to the grounds of possession you see in Schedule 2 to the Housing Act of 1988. But they are assured tenancies. We'll see on the later slide, they are also subject to forfeiture proceedings, however. The Housing and Planning Act reference is merely to the fact that there was an attempt, or rather there is legislation which suggests that the idea of periodic tenancies will go out of the window and they will be replaced by fixed term flexible tenancies, particularly for local authorities. I'm glad to say that trend is reversing in any event. That hasn't come into force, and therefore the death of what they call lifetime tenancies is no longer, at the moment anyway, on the table. And I think most people can see there are more problems with fixed term and flexible tenancies than solutions. So why is the distinction important? Well, I've already addressed this in part at the start of the process, start of this section. I explained why we were dealing with this. The terms of the agreement is going to be different. We've seen that already from Triplerose's case. And of course, we'll see it in terms of periodic tenancies shortly. The statutory oversight is different. Well, if you take an obvious example, Section 15A of the Housing Act 1988, which doesn't apply to shared ownership, says that if you have sublet your property, the whole of your property, or parted with possession of the whole of the property, you cannot regain security of tenure, whether you move back in or not. And that mirrors, of course, the provisions you see in Section 93, subsection 2 of the Housing Act 1985 for secure tenancies. Well, that obviously applies not to long leases. So the statutory oversight is different. And it's why, incidentally, it's important to deal with subletting as soon as possible for periodic tenancies and fixed-term tenancies. And the remedies are different. Injunctions and possession actions, of course. Declarations of breach may be required, particularly for the shared ownership and long leases. And of course, in some cases, you have to go down the forfeiture route. And in some cases, you have to go down the statutory ground route. And so the distinction is important. If we then go on to what I consider the key question of, is a short-term let a subletting or parting with possession? It's an issue that I've grappled with over the last few years. And I remember going to a training course on fraud and being asked about this. And my indication at the time to the local authority was, well, I don't see why not. It's an obvious question, of course, but it is a letting, I would say. It is for a fixed period, it is for a payment, and it is subject to the terms of the short-term let for exclusive possession, so I don't see why not. It's especially important, as I say, for periodic tenancies or for non-long leases, i.e. for the flexible tenancies for local authorities or for the fixed-term tenancies for housing associations. I should just say that there are no special rules within the legislation for short-term lets. We are looking at established case law, we are looking at established statutes, Housing Act 88, Housing Act 85, etc. So there's nothing special about that. I should also just give a warning at this case, there is often a confusion which hopefully we will clarify by the end of this session between, yes, but what if they move back in? Or what if their intention as a tenant is to move back? So they're only letting it for a short time, but they're going to be moving back when they return to the country. That is not the issue. The issue is if you've sublet, you've lost security of tenure. And that's the crucial point. And that's why we have to deal with the section first. And I've already mentioned the various provisions which make it clear that if you sublet or parted with possession of the whole of the demise, that is the end of the story. I've also introduced the question of City of Westminster and Harman, and there may be people listening to this who were involved in that case. A very interesting case, and of course got a lot of publicity, often misdescribed in the press as the tenant being fined. He wasn't fined. There was an unlawful profit order made against him because he was found to have sublet his local authority flat through Airbnb for a number of years. And so you had a normal, albeit a very high, unlawful profit order. It is relevant as far as I'm concerned, not so much for the amount of the unlawful profit order, but for the fact that the court, albeit a county court at district judge level, found it to be a sublet. Didn't have any problems in finding it a subletting. And of course, it was a case where Mr. Harman wasn't living at the property in any event, which made that finding all the easier. So he wasn't sharing it, he wasn't going backwards and forwards to it. And it's a case which eventually reached His Honour Judge Luber, like so many housing cases do, and he didn't get anywhere on his appeal. So that's a useful indication, albeit not a precedent authority, for the notion that Airbnb, Booking.com, etc. Are in fact capable, I stress that word capable because it depends on the circumstances, of being sublets. And if one looks at what I call a traditional view of subletting, we've all done skeleton arguments on these matters, we've all looked at skeleton arguments, or we've all read them or had them referred to. Hussey and Camden is an obvious one. not just because it makes clear that security of tenure in an only a principal home case would come at the expiry of the notice to quit, but also because it made it quite clear what the real issue is about the question of subletting. In other words, did the occupier enjoy exclusive possession? And that was the clear point. And if you see the last couple of lines after the highlighted section, Mr. Hussey's right to enter and use the premises, if and when he chose, was not negatived. There might have been proof that he gave up his key, or of the manner in which rent was paid either to him or by another in his stead. There was no such evidence. So normally a tenant would try and make it clear that, okay, somebody else was staying at the property when I wasn't, but I wasn't subletting it because I was able to come back and forward to the property, and therefore there wasn't exclusive possession, and there wasn't that evidence put forward to suggest otherwise in the Hussey case. And in fact, I remember a case I had before District Judge Desai, who's a judge who will come up shortly, as at the Stratford Centre, where somebody was had an intermediate rent tenancy for a housing association and had never moved in. She claimed to have separated from her husband in an employment such as to qualify for the intermediate housing, and she was using booking.com. And indeed, at the day of the hearing, we went online and found the advert, and I offered the booking to the judge, which she didn't take up, but generally accepted, no problem at all. It was subletting. Yeah, she'd never lived there, and she was using it for a series of short-term lets. It was subletting, and she was also subject to an unlawful profit order under Section 5 of the Prevention of Social Housing Fraud Act. Just to reinforce the point, Street and Mountford, for anyone who's been to university in respect of law, and in fact, even if you haven't, Street and Mountford is still a case that people cite again and again. In other words, it's about what is a tenancy and what is a license. Well, a tenancy is characterised as exclusive possession for a period and for a payment for that period. And it's there to distinguish it, for example, between a license stroke lodger situation. And therefore, that is normally what you start off with. And clearly there is an intention to create legal relations because a tenancy is a contract after all, and there must be that intention. But it's those functions that are particularly important: exclusive possession for a period and for payment of that period. It's why in hostile situations you'll get landlords saying, well, I do the laundry, or I have the right to enter the room to clean the room, or whatever, to show that it's not exclusive possession. Or people say that that person, yes, he was in my property, but he's just a mate, or he's just a relative. He's not paying anything, so it's not a tenancy. I have cited the case of Bermondsey Exchange, freeholders, and Cumetto. Don't need to worry about the fact that they were bankrupt by the time of the hearing. But I've cited that case because it's another Airbnb case. It also involves Judge Luber, so it's not a precedent case, but it's an important case given the quality of the judge. In May 2018, at the County Court at Central London, of course. And it had been a claim for an injunction in a long lease case because of the use of the property for short-term lets. Ironically, under the lease, there was no problem subletting the property at all. But there was a problem in how the property was being used by this particular tenant in short-term lets. And the reason for that, and if I just quickly can go on to a later slide, you can see the 4 long lease provisions, which is from the Bermondsey case. This is what the lessee was not entitled. He was not entitled to assign, sublet, or part with possession of part. Well, that wasn't a problem in Bermondsey because the allegation was they did it to the whole. So that wasn't found proven. In fact, it wasn't really alleged. Secondly, not to part with or share with possession of the whole of the premises, or permit any company or person to occupy the same by way of assignment or under lease of the whole of the premises. Thirdly, not to assign or underlet the whole of the premises without prior written consent. And fourthly, not to permit the use of the demised premises or any part thereof otherwise than as a residential flat with the occupation of one family only. And that's not too dissimilar, of course, from the Triplerose case we saw earlier on. And in this case, as I say, the issue to do with number 1, the part, possession of part, wasn't an issue. Airbnb, it was found may be a sublet, and you can see what Judge Luber said about that. neither the short duration of the arrangement, nor any notional provision for services, such as leaving the flat stocked with material from which to assemble a breakfast or other meal, nor reservation of a right of entry, nor any combination of those features displace that presumption from applying to an Airbnb style arrangement. And so made it quite clear, therefore, that a short-term let can constitute a subletting. And the fact that it was in the context of a long lease doesn't make any difference, because they're looking at underletting and subletting in the same context. And so it does depend upon, as far as we're concerned with the periodic and the fixed term tenancies, it does depend a lot, of course, on, to put it mildly, the whereabouts of the tenants. Just before we get on to that, just want to deal with very quickly the parting with possession. Parting with possession, one always sees that. It's subletting or parting with possession of the whole. One always sees that, but the reality is that subletting is a form of parting with possession. Parting with possession, and this is very generalised, and I don't mean this in a very precise sense, but it can include, for example, you're not subletting because you're not charging. You know, if I let my brother to have my house and, you know, I've got somewhere else to live or I've gone abroad or whatever, I may well have been treated as parting with possession. In other words, it doesn't matter that there's no rent being charged. It doesn't matter that one can perhaps characterise it as a licence. It's a question of the fact that, yes, but is he entitled to be there? And is he entitled to exclude me? And the answer may well be on the facts, yes, in which case I have parted with possession. And many of us would have come across cases where the tenant has abandoned the property. I remember doing a case for one housing association where the tenant had left about 25 years before. And a very pleasant person was in occupation and had been there for the previous 25 years. And she said the former tenant had let her in. She didn't pay rent, but she paid the occasional lump sum payments to him. But she hadn't seen him for the last 14 years. It was a parting with possession. Clearly, there was no subletting happening anymore. It was a parting with possession. But that was still, of course, not allowed under the tenancy, and therefore a notice to quit was served along with a notice seeking possession in the alternative. So it can be a parting with possession, but as I say, the short-term lets, you're charging money, so I don't think this really adds too much to it. Looking at breaches of tenancy, because of course you may get cases where people are only subletting part of the premises, so they may be staying there, like the friend I mentioned, may be staying there, so there's no subletting of the whole. There may be alternative causes of action, such as reliance on breaches of tenancy. The long lease, as I say, are the examples from Bermondsey. They're fairly typical, although the wording is important. But with the periodic fixed term, of course, fixed term I mean flexible as well for for local authority landlords. You're going to have an only or principal home provision. One has that anyway implied by statute, because section 81 of the 1985 Act would imply it into a secure tenancy, and section 1 of the 88 Act would imply it into an assured tenancy. You need to use it for residential use. But of course, if you've got using it as your only or principal home, it's implicit in that in any event. And you mustn't sublet or part with possession of the whole. Well, that's fairly obvious, and I've already mentioned the fact that, of course, the effect of that is that you lose security of tenure permanently, and that's the section 93 subsection 2 of the 85 Act, and that's the section 15A of the 88 Act for assured tenancies, or indeed in part where you may need to have the consent. So it may be no problem. You're certainly, for example, entitled under section 93 for a local authority tenancy to have lodgers, and you're entitled to sublet the part of the property with consent. But you may not have that consent, and you may say that person isn't a lodger. They are subletting the premises because there's exclusive possession that they have, and there's no services being provided such as to make them a lodger. So those are important terms, but fairly typical terms. The only or principal home, of course, and I'll just stress spelling principal right. It's the only thing that, well, it's not the only thing that annoys me. It's one of the things that annoys me, principal being spelled right. But the importance of it is, of course, one can go in and out of security of tenure if one isn't subletting or parting with possession of the whole. You know, so if I've got a council flat and I stay with a partner, I can do that as long as I don't sublet the whole of my flat or part with possession of it and get back in the property before the expiry of the notice to quit, which my landlord may serve, with a periodic tenancy in any event. So owning a principal home is important, but as I say, often not really the issue with Airbnb. Where I say it may lead to notice to quit, I have to underline may, of course, because what about if we're dealing with a fixed term tenancy? As I say, they're on their way out, I'm glad to say, but one of the problems with fraud and fixed term tenancies is that with a weekly tenancy or a monthly tenancy, the tenancy ends at the end of every week or every month, and therefore is extended when there's no notice to quit given by the tenants. So it's automatically extended, and therefore it's a running tenancy. Well, if you've got a 5-year tenancy, it's exactly the same thing. It's a 5-year tenancy, which of course there are provisions to end that at the end of the period. There may be break clause provisions to do so with a fixed term, with a flexible tenancy after 2 years in particular. But the difficulties is that what you can't do is that you can't serve a notice to quit. And that really creates a problem. And so if I've got the kind of case where I have somebody who is on a fixed term tenancy and there is no break clause that can be operated, and that they are not living there as their only or principal home, whether or not they've sublet, they're not living there as only a principal home. The difficulty, of course, is that they're no longer covered by the 1988 Act. They no longer have security of tenure because they need to live at the property as their only or principal home to retain that security of tenure. And so I can't serve a notice to quit because the tenancy still has 3 or 4 years to run. It's not a weekly or a monthly tenancy. I must go down the forfeiture route. And that is one of the problems. And so it is a difficulty, I think, with fixed term tenancies, and the same, of course, for flexible tenancy. And equally, of course, be cautious about cases like Islington and Boyle and Ibidon, which I cited there, not because there's any doubt about the good sense of them, and I always put them in the skeleton arguments on the right case. But as I say, if you sublet the whole, then you don't regain security of tenure unless it's a shared ownership. Long leases, of course, aren't covered by the Act in any event. So be careful that, the fact that, for example, I may be going abroad to work for 12 months and I say to somebody, look, I'm going to let you lease my flat for that 12-month period, but, when I come back, I want it. Well, I've sublet the whole of my flat. The fact that I have an intention to return, objective or subjective, of course, it's really an objective test, doesn't matter. The fact of the matter is I've sublet my flat, and therefore under section 15A, I've lost security of tenure. And therefore objective intention to return and own your principal home is fairly irrelevant. Subletting of part, I'd be a little bit cautious, and I appreciate I was the one who wrote this, but I'd be a bit cautious about Marlow because it's an odd case where people have been living together. The tenant and the defendant had been living together in a property before the tenant was allocated a property with Monmouth Borough Council. And there was a question of whether, in fact, the defendant was actually a tenant of the tenant, as it were, a subtenant of the tenant. And they said, well, no, they weren't. And there was no intention to create legal relations. And the argument, well, maybe they have exclusive possession of the property. I'll just read from the judgment. At most, this is what the judge said about the court below. He found that there was an exclusive right to use or enjoy the 2 bedrooms, but not one which prevented Mr. Roberts, that's the tenant, from entering the room if he wished to do so on some reasonable grounds. Moreover, on the basis of the entirely informal nature of the arrangement, it would be simply ludicrous to suggest that there had been an intention between the 2 persons to create the relationship of landlord and tenant. So if the tenant remains in occupation, as they did in Monmouth, then of course it's going to be I wouldn't say difficult, but it's going to be something you have to look carefully at whether the subtenant is a subtenant or is a lodger stroke licensee. And it depends on the facts of the case. Broad clauses are preferable, and we've seen that in a number of instances. Swan and Ecker was referred to in the Bermondsey case. And of course, there's nothing to stop you putting in your tenancy agreements something specific to short-term lets, whether that's requiring permission or whether that's saying that it's not allowed. There's nothing to say that that shouldn't be done. But equally, one may need to have broad terms, because part of the problem, and this is particularly a lease problem where a lot of them are off the shelf from old precedents, is that they are using a form of words which is not applicable to the modern agenda. It's not really, there was no Airbnb or booking.com or whatever around at the time, and therefore you're trying to shoehorn a situation which wasn't actually around at the relevant time, and therefore keeping it as broad as possible. And that's in particular in relation to residential clauses, where you're trying to say, well, look, it's not about is somebody living there, that's residential in one sense, so that we don't have to argue in Triplerose, etc. That's still not residential use. Let's make it clear that it's residential use by the tenant and keep it as broad as possible. And I've just set down there for your use and for your reading, I'll say you'll get a copy of these, some residential use cases. We've seen Bermondsey and we've seen Nemkova, and those are the relevant parts in relation to residential use. So Luba, I'm in entire agreement with the judge. The user covenant is clear. It's breached when the flat is not being used as a residential flat as a short-term temporary accommodation for transient, and I've underlined transient, visitors paying for such by way of commercial hire. Nemkova at 33 says that on the facts found by the FTT, the individuals who occupied the flat for weekends or other short periods after responding to internet adverts, not using the flat as a private dwelling house for occupation by one family at any one time. Remembering, of course, that traditional Airbnb use, i.e. you're using it for a few days or you're working somewhere and so you're using it for a couple of weeks while you're working elsewhere, you've still got somewhere else. It's not your principal home. It is transient. It is therefore not your residence, and therefore that's highly relevant as to whether in fact you breach the residential clause. And another case is given at the bottom with foul or commercial, just to reinforce the point. So there's a fair consistency of view that you may have problems using Airbnb. And as I say, that can often seem odd, where you have cases and long leases which don't mind subletting, but they do mind Airbnb arrangement, or may mind without consent. And partly that's because of worries about the characterization of an area with lots of people coming and going, or maybe the attendant antisocial behavior that may be created. And that's not even just talking about those going on Airbnb for the parties. And I've dealt with Triplerose, and these are really just some of the salient explanations as to the reason for the conclusion about the residence period. And so you can see those for yourself. So that's the position as we presently stand, it seems to me. They are up to debate. They are very fact specific. One needs to look at the arrangements between Airbnb, booking.com and the tenant. One needs to look at the arrangements between the tenant and the occupier. One needs to look at the position of the tenant and what they're doing, and whether, for example, they're just away for a couple of days, or whether in fact they've been living elsewhere. One needs to look at that. But what is the implication, therefore, of any of that if one decides that no, this is not allowed for under the tenancy or under the lease or under the shared ownership agreement, and we wish to take action? Well, of course, the options are effectively court action, whether that's possession or injunction, and or trying to get some money back. And just very quickly then, so that we've got some time for questions, I've dealt with coronavirus issues. There are real issues of investigation, of course, because a lot of staff have been furloughed, a lot of staff have been reallocated to other resources, not least homelessness, if you're a local authority, and customer support if you're a housing association. And of course, there are difficulties anyway. I mean, it's notoriously difficult to get information out of it, Airbnb. They're not being a company obviously based in this country. And so there are difficulties getting the information. But that's not particularly because of coronavirus, that latter point. But I would just stress that there's no restriction on getting determinations of breach if you're going to be going for forfeiture. And I just wanted to clarify that when we talk about forfeiture, it's important with shared ownership to read section 169, I think it is 169, which makes it clear that a shared ownership does require that declaration, even if you haven't yet staircased up to 100%. I think maybe in one of the earlier slides indicated otherwise, but section 169 makes it clear that for the purposes of section 168 and 169, it doesn't matter whether you staircase up to 100%, and that's still available. You can still get those declarations, which are necessary for other than rent breaches of long leases, and that would include the shared ownerships. There is a current stay, but of course under CPR 5529, but of course claims can be issued. And of course, remembering that most notices to quit are unaffected by the general move to 3-month notices. There are exceptions to that in respect of Rent Act 1977 notices, if one reads Schedule 29, but what I would call an ordinary notice to quit is still the same, 28 days or month, depending upon whether it's a weekly or monthly tenancy. It's still the same. So one can still serve notices and one can still issue proceedings. It's difficult, obviously, to do much more than that until we see what happens after the 23rd of August of this year. One might look at injunctions, and certainly with shared ownership cases, it is, as I mentioned at the start, quite difficult to remind yourself that on the one hand, there are assured tenancies, and if the tenant remains in occupation, you're entitled to issue notices seeking possession. So if you're saying that they haven't sublet the whole or whatever, there is still security of tenure, but because they're still living there in the shared ownership situation, you can still serve a notice under ground 12 for breach of tenancy, for example. You don't have to go through forfeiture proceedings. You would go through forfeiture proceedings if the tenant wasn't living there any longer because they were no longer covered by security of tenure as provided for by the Housing Act 1988, and therefore the grounds for possession are no longer applicable whilst they no longer live at the property as their only or principal home. So injunctions, you can still use it for possession proceedings, but commonly, particularly as I say, where the tenant is there, injunctions are often useful to say, look, you can't do this under the lease, and this is an injunction to prevent you doing that. And that is often a better way of dealing with the matter, and a more effective way of dealing with the matter. And of course, that was what the Bermondsey case was looking at. They are discretionary, but one might say that they're proportionate and therefore they are worth considering. And of course, the court is in particular looking at likelihood of future breaches. Somebody who did something 2 years ago is one side of the equation. Somebody who's been doing it regularly and there's evidence that they've been letting out properties. There's email evidence from the occupiers saying what a great time they had, etc. That's at the other side of the coin. And so one looks at whether an injunction is going to be effective. As for money claims, again, very quickly, because we've got 10 minutes left, so we've got some time for the questions. Unlawful profit orders, clearly that's available under the Prevention of Social Housing and Fraud Act 2013, Section 5. That's effectively for the subletting. We've already seen the example of City of Westminster and Harman, very impressive performance by all. I think it was Sam Phillips actually at 5 Paper, but very impressive by City of Westminster in that case and Sam. One can get unlawful profit orders. And of course, one might say, yes, but it's a bit academic, isn't it? You know, are you going to recover it? But a lot of these cases, somebody has other property available, so you can put charges on those and orders for sale. So it is worth doing it. But of course, that's only for sublettings. What about the tort of deceit? Well, it's a difficult one because the tort of deceit is useful for allocation fraud. So where somebody has lied or misrepresented something recklessly for the purpose of getting the housing, then obviously you can do it because there's a representation which has caused you to act in a certain way, i.e. allocate the property. And there are some very good cases, you'll see from my blog, which talk about the fact that you can, if you're a local authority, you can recover the cost of temporary accommodation from a family who should have had that property rather than the one who did. It's unlikely in a short-term let case to apply because normally there's no relationship between the landlord and the tenant at all over this issue of short-term lets. I've put the third one in just because I'm trying to get the bandwagon going. Disgorgement is, I'm just going to read out one of the definitions, is a repayment of ill-gotten gains that is imposed on wrongdoers by the courts. I did this because I've got a claim at the moment where there's a shared ownership issue, and there have been past periods of subletting, and there have been periods where the person has also got two other shared ownership properties and just sublet those as well. And I wouldn't mind us, i.e. the Housing Association, having some of that money. Not all of it is going to be subletting. Obviously, we would say she shouldn't have had the third shared ownership in the same year anyway, and therefore she's benefited from that, and therefore we should be able to get some of the profit. It's a very difficult legal concept. It's not one that's very common. In fact, my opponent has said it doesn't exist. We're obviously during the stay period, so we haven't got a hearing on that. But I do think a restitutionary remedy such as that is worth looking at. Maybe you'd need an account to find out exactly from, in this case, her various activities she gained from her deceit. And lastly, I just want to raise the recent case, 2020 case of East End Homes and Sing. You might have seen it again on our Twitter account. You might have seen it in any event. Some very good work again from the lawyers concerned. It's a long lease. Mr. Singh was rumbled. I think he tried to claim that a third party was doing it all, but that was clearly not right. And in the end, I think a deal was done. He lost in the first tier tribunal, who said that he had breached the terms of his lease and that therefore a declaration of breach should be given. And I think he ended up paying something in the region of £48,000 profit and costs to East End Homes as a quid pro quo from you can stay there. That is something worth thinking about. Of course, there are, particularly with the long lease cases, not so much with the periodic fixed term tenancy cases, but with the long lease cases, or even the shared ownerships to a lesser extent, one might have that kind of negotiation that, you know, we don't see why you should have profited from that. And therefore, there is that case. I should just say as a quick aside, you sometimes worry about whether there is a problem as to the proceeds of the subletting, because they undoubtedly haven't been declared for income revenue purposes. So there's always that issue, but all in all, I think it was an excellent result obtained by the Housing Association and their solicitors, so all credit to them. And that is what is the current position. So before I have a look at what questions people have, can I just perhaps recap by saying this, and it's that short-term lets are a problem for periodic tenancies. They may be just simply a breach of tenancy because they may not be a subletting of the whole. They may simply be a subletting of the part without permission, and therefore they are a breach of tenancy. With fixed-term tenancies and flexible tenancies, it's exactly the same analysis. It's simply that in terms of how one deals with that may be different. If it is only of the part and the tenant has remained throughout, then of course you can issue your notice to seeking possession in the normal way, subject obviously to the current restrictions. And you can take possession proceedings along that route. With long leases, you undoubtedly would be trying to prove residential use or lack of residential use as required by the lease. You'd be trying to show underletting of the whole or part, which is undoubtedly part of the lease's provisions, and you will either be going, or you can do both of course, down the possession route via the 168 declaration and forfeiture proceedings, and or injunction proceedings, and of course money claims come on top of that. So it's not all bad. It is a lot of activity, and really the devil is in the detail, and each case is different. So one has to look at the arrangement, one has to look at the history, and one has to look at how this has been dealt with. So if I have a look now at what I have as the chat, somebody has asked, could you clarify, is a sublet of the whole not an irreparable breach in a shared ownership case? It's a very good question from Alex. I think there has been competing views on that. I think particularly with the shared ownership lease and the purposes of shared ownership lease. And I've often been surprised at the lack of clarity in the shared ownership terms as to what the purpose of it is, because you are still an assured tenant. But it's certainly an argument, that's all I would say. But there are arguments the other way that I've had. But it's a very good point, and one I should have raised earlier. So you may argue in a shared ownership long lease case that it's an irreparable breach, and therefore there can be no relief from forfeiture if you go down the possession route. Let's see if I can operate this properly. Is disgorgement a possible alternative to an account of profits in the private sector for breach of a long lease? Yes, I mean, I think it is, because when one looks at damages claims, one is either going to claim under a breach of lease or tenancy, or one's going to a claim for a tortious remedy, such as the tort of deceit, or one has a statutory remedy, such as the unlawful profit order. And there does seem to be a lacuna, and that's why I say disgorgement seemed to be that lacuna. I've been asked what terms might you suggest could be included in the secure stroke flexible tenancy to restrict Airbnb similar use. Well, you have to decide what your approach to it is. And by that I mean, it doesn't necessarily mean it's all bad. You know, there may be, as I said at the start, you may be quite happy if tenants want to use their properties from time to time, as long as they remain there as their only or principal home, and perhaps as long as they get permission. But obviously what you don't want, and in fact they're not allowed to do, is they're not allowed to move out themselves. And you maybe want to make it clear in any tenancy terms that they must not use the demised premises in their entirety at any time for use of short-term lets, such as Airbnb. But in terms of the precise drafting, it depends what you're trying to restrict. Some of it you're trying to restrict what the law is, and some of it you're just trying to say, this is what we as a housing association or as a local authority want to do. And just to give you one analogy, I noticed a lot of local authorities now, or rather some, and probably increasing number of local authorities now, are providing in their tenancy agreements against people owning second properties, which is suitable for their occupation. And saying, well, look, if you've got a second property suitable for your occupation, good luck to you. You know, your circumstances have picked up, but you shouldn't be in social housing, and it's a breach of tenancy. It's the same with, in some senses, with the Airbnb. I've been asked about at what point would advertising on Airbnb constitute running a business. The point about it is about the running a business, and the point in the cases I cited was it depends on the nature of the term. Because as you know, the restrictions are normally about running a business from the demised premises. It's not about running a business per se, because obviously a tenant's entitled to run a business and have a business. It's running a business and about where you're running that business from. And as I say, depending upon how the term is phrased, and you can term it so that it will count as a business, but you've got to be very precise. It may be said, well, no, it's Airbnb that's running a business and that you're just advertising on that. And that therefore, you know, it's not running a business. But you can have a term of tenancy that makes it quite clear that that's something that's not allowed under the lease, and very specific to that. And all that any tribunal is doing, first tier or upper tribunal, is simply interpreting the clause. They're not, you know, looking at case law in terms of what's allowed or statute as to what's allowed or not allowed. They're simply saying, you know, this is what we want to do or not want to do, and allow or not allow. I'm going to try and have a look at some of these other questions. If a tenant pays council tax, gas, electricity and rent, can't they prove they're in occupation? No. A sensible tenant retains, sensible fraud, retains the council tax in their account, because obviously it's one of the things you might look at as a landlord. You know, why is the council tax account in X's name when in fact you're the tenant? So the mere fact that you're, even if you're paying it yourself, paying council tax, or at least have it in your name, or keep the utility accounts in your name, doesn't prove at all you're in occupation. Quite the opposite, it's neutral. And as I say, my normal reaction is you'd have to be fairly stupid to put it in your subtenant's name. And there are some fairly stupid people there, so it is sometimes the case. But no, it would just simply mean that what I'd be looking for is that, well, wait a minute, it's obviously much easier with smaller units, but you've got a one-bedroom flat, and yet your neighbours say that somebody is that's not you, clearly not you, is coming in and out of that flat and has been for the last 6 months, and they haven't seen you for 6 months. And that normally is the start of the process to say, well, why is that? You know, and when you go round, you knock on the door, somebody speaks to you and says, you know, either they tell the truth and saying, well, we're letting it off so-and-so, or that we're here because we're for a couple of weeks, because we're in the country for a couple of weeks and we've got it through booking.com, and off you go. So it's fairly kind of neutral, the question of council tax accounts and so on. Katrina has always helpfully said about Airbnb insisting on a court order from California, although she makes the point they carry on business in the UK. I think there's also been action in respect of their Irish location as well. But Katrina would know better than me about that. But yes, there are practical problems about getting information out of Airbnb. Most of the information I have seen have been from email accounts and from third parties, and have been from people leaving reviews, which are obviously public. Yeah, so somebody's still advertising on the site, and here's the reviews for this property. You can see that they've been using it for some time. So that's normally where you get it from. I've been asked, would it be reasonable to refuse permission for short-term lets of a room if a tenant is not intended to be present the whole time the person is on the premises? Well, it depends why they're not intended to be present on the whole time. If I've got work in Sweden for, so I'm a bit obsessed by Abba. If I've got work in Sweden for 4 months, well, again, you've got to be very careful. If I've got a 2-bedroom flat, it's one thing to say, well, for one of those rooms, I'm going to allow somebody to stay under a short-term let arrangement, and you may or may not need to get permission of your landlord. But obviously, if I let out the whole property, because I'm not going to be there, then I'm in trouble, because we go back to the street in Mountford. It's exclusive possession, depending upon the terms and the reality of the facts, for a term at a rent. You know, why is it not a short-term let? So one has to be very careful, even if one's trying to do it legitimately and trying to be sensible. And I remember a case some years ago, I think it was at Clerkenwell, where we had somebody who said that she had moved in with her what she called it her mother, but I think it was somebody who brought her up because of her ill health. And we thought, well, that's fair enough. I mean, that's all good stuff. But you know, you do seem to have let your property to somebody and charged them £1,000 deposit. So, you know, one's got to be very careful about these things, as you know, even if you're trying to do it legitimately. And I would be very cautious advising somebody, and I'd be saying, at the very least, do not let the whole of the property. And somebody mentions, which is very helpful, about the Westminster were able to get the evidence for their £100,000 order via the tenant's bank statements rather than going to Airbnb. Absolutely right. I mean, you know, you've got, of course, under the Prevention of Social Housing Fraud Act, local authorities have their investigation powers, and that would include, of course, going to banks and finding out what the statements say and what they don't say. Somebody might be cuter than that, and they may go through third parties, and that can cause problems, but that's a very helpful contribution. So thank you very much for that. Somebody says, a local authority, they're looking to impose a license condition in a selective license to prevent premises from being used as Airbnbs. Have the other local authorities? Well, I'll just throw that open, and not for answer now, but I think as you said, Farah, I think it is a selective licensing issue rather than additional licensing or mandatory HMO licensing issue, because as I say, they're not the person's only or main residence. So that would knock out the HMO side, but it may apply to selective licensing if you wanted to include it as your conditions. And I can see why you might want to do that. So, let me just have a quick check of any more. Do you feel that an Airbnb breach whilst a tenant is on site as a host is sufficient for court action, or should this be dealt with via initial warning letters? Well, it depends what you mean by on site. And if you mean that they're living there, it's a question of evidence, isn't it? I mean, if what you're saying is that it's a breach of tenancy because they've sublet part, or you've got specific provision in your tenancy about Airbnb, then all well and good. You know, it's a question of reasonableness, and you may just want to be preventing them doing it in future. You can do that by an injunction, of course, but equally, a suspended order for 2 to 5 years might be just as good. In terms of any pre-action, I'm a great fan of detailed pre-action letters. Normally they don't get answered, but it always helps to be able to say, look, we gave them the opportunity to explain. If it was as innocent as they said, why didn't they just tell us that? That's useful. Alan has said that Airbnb, Ireland Law Enforcement Liaison, is the most difficult and helpful organisation, so ignore what I said about Ireland, but it is a practical problem about getting information from Airbnb, but there we are. Would it be reasonable to refuse permission for short-term let if the tenant's not intended to be, I know you've dealt with that one. Let me see, spoke to a local authority last week, and the basis for them believing that he was in occupation was because he was paying the rent. Well, I think this is just a comment, but as the person commenting makes it quite clear, receipt of rent from the person is just being sensible. I've always taken the view, if you're going to do it properly, and don't be stupid. And therefore you would invariably still get money from the tenant. It's things, isn't it? The obvious things, like when nobody ever asks us about repairs, or we've never seen the tenant, and they pay their rent by direct debit, and, or they pay in lump sums every 3 or 4 months. Somebody mentions about, for clarity on the Airbnb type short lettings, as an awful sublets, I'd assume that exclusive possession would be hard to prove, as most would only hand out spare keys and retain belongings in the property. That's absolutely right. And therefore, the suggestion is that it's just a license. It really does depend on the facts. It really is dependent upon the facts. I've already indicated, and I appreciate at county court level, some very clear decisions as to the fact that they are sublet. And I've also indicated at Upper Tribunal level, in the context of declarations of breach for long leases, that they are treated, or can be treated, as underlets, which is the same thing effectively. But it does depend on the facts. And it does seem to me that it's a question of that quality of right. In other words, if I've gone to a property for 2 weeks, if the owner, or the tenant in this case, cannot get in, well, I've got exclusive possession. And the fact I've got it for 2 weeks and not for 2 months or 2 years or whatever one would normally have, I don't think necessarily it's an argument. What I would say, Rebecca, is that if you have somebody on the other side properly arguing it, and of course I don't think in Westminster's case, for example, I don't think Mr. Harman was represented, you may well get those kind of arguments that it wasn't a subletting, the person was at best a licensee, and therefore, there's no breach of the tenancy because, of course, you're entitled to have lodgers, and yes, you may be in breach of benefit declarations, you may be in breach of tax issues, but you're not in breach of your tenancy. So I agree, it's an argument. But I have come to the conclusion that, depending upon the facts, it's certainly not something to throw out of the mix, and I would certainly be very keen, and there's going to be an appeal at some stage on it, of course, to continue it at an appellate level. What else have we got? Yeah, somebody mentions about the case, and Tristan Salter also did work on the case. So yes, heads up to him. So, and Karen as well. So very, very well done, Karen. It's an excellent case, and as I say, everyone in it should get a round of applause. And I think it was a very effective case, that City of Westminster and Harman. So well done all on that one. What's your view on making a booking and staying at an Airbnb let property to evidence its use by that platform? Yeah, Mark, and that's the kind of thing that certain persons I'm not going to mention would do. It's evidence, isn't it? And yes, it may be evidence as to the type of letting as well, because if they're saying that they're always there themselves and the person only has use of one of the rooms and blah blah blah, if you did it yourself or get somebody to do it as a third party, one may be able to do that, and and may say, well, actually, I booked it and I had use of run of the whole place, and my agreement made no mention about any rights of the tenant to come back to the property until after my stay had finished. So you're absolutely right on that one, Mark. So it's an interesting way forward in the right case. Normally, my experiences of Airbnb cases is that there is sufficient information on it. I mean, I do have a case at the moment where the person is claiming that he didn't, and it was his friends, and that his partner who's not his partner, who sometimes is his partner, depending upon which tribunal he's before, you know, is the one whose name is on there and he has nothing to do with it. He's entitled to work abroad and he didn't have anything to do with this, etc. So you do get that kind of argument, but it's not an easy one. At what point would a short-term let become a lodger? It's normally the other way around in a way, because, as I say, it's not about time, although time may help. You can be a lodger for a long time. You can be a lodger for years. It depends on the nature of the arrangement, remember, with lodgers. It's not a very precise definition, but normally, you know, if you look at, as I say, obvious lodgers in hostels, it's because there are services provided. And although, of course, they have their own room, there's normally services provided, which is why you get tenancy agreements saying things like, in homelessness cases, for example, about the ability to move people from room to room, or the ability to clean the room, or facilities being offered, such as breakfast or laundry or whatever, which maybe goes down on the side of a lodger rather than a tenant, a subtenant of part. So it does depend on the facts. Will a long lease now need a selective license to operate an Airbnb? As always, ask Dean. But in reality, as somebody who's just said, I think you would need to make provision for it in your selective licensing scheme, or at least it would be better to do so. I don't think it automatically would be covered, but it depends on the nature of your scheme. And as Farah has said, it may be that imposing a particular license condition may be the way forward in respect of that. I think I have probably gone through, not all of them, I know, but in terms of the screen I think I've gone through all of them. Most of you, and in fact, I think on this last slide, you will have my email address. If people do have queries, as always, please don't hesitate to ask me or indeed any of the team. And many of you know me anyway, so don't bring up yet, but please, as always, let me know. So can I just thank you all very much. Some great questions. Sorry I overran, and I'm going to let you get on and enjoy the rest of the day. So take care, stay healthy, and hopefully we'll be in touch soon. All the best.